Hi there. I want to talk to you today about a Florida power of attorney. Well, the first thing is, what is a power of attorney? So a power of attorney is a legal document, and it is already stated in the Florida statute, chapter 709. So with this document, you can name an agent, someone you fully trust with your life, with your assets. So you can name that person to act on your behalf in the event you become incapacitated. Well, here's the big wrinkle with this is that prior to 2011, you can make a power of attorney a spring-in power of attorney. All that means is that you could have had a power of attorney prior to 2011 that says when this happens, then the power of attorney would become effective. That's no longer the case. In Florida, powers of attorney are effective immediately you sign it, with the exception of course, a special power of attorney, which is, for example, you need someone to sign closing documents on your behalf because you're going to be out of town. Well, that's a special power of attorney, and then that power of attorney would no longer be effective after that action is taken. So back to a power of attorney. So in Florida, a power of attorney, as I said, is effective immediately. A power of attorney is important because it can avoid a Florida guardianship, which in most cases should be avoided. Well, here's the wrinkle. You can have a general power of attorney or a durable power of attorney. The issue is the general power of attorney, although it is also effective immediately, it does not survive incapacity. So here is an example. You have just a general power of attorney, you become incapacitated in Florida, that power of attorney would not be effective. So you would need to have a durable power of attorney because it survives incapacity. One question that I hear a lot is, can I use the power of attorney after the principal or the person that created the power of attorney dies? And the answer is a power of attorney does not survive death, so you cannot use it. So with a power of attorney, I always recommend that not only do you name the primary agent, the first person to act, you should also have a secondary person. You could actually have more than one secondary person. So you can have a first person, a second person to act, or a third person, or even a fourth person. Another thing that I don't usually recommend is that you name joint agents, because a lot of the banks are not going to want to work with two representatives or two agents. They're going to only want to work with one. But that's my suggestion, right? And most of the time, they're going to require that the agents, if you name two persons, that they act in unison. So they have to be on the same page about everything. The other thing that I would suggest is that if you have a power of attorney, is that you present it to the bank so that way they can evaluate it before it's needed, right? So the power of attorney is an excellent document to have, but with one caveat. You have to give that power to someone, again, that you trust implicitly, someone who is not going to go behind your back and steal your property. If you have questions about a Florida power of attorney, you can reach me by calling the office 954-404-8274, or you can go to my website, carolgrantlaw.com, and make an appointment. Have yourself a fantastic day.